Hi, everyone. We hope that you're having a good afternoon. You're joining the first webinar of 2022 of the Gian Monnet module in European and International Environmental Law, hosted by the University of Siena. It's the first webinar in a few months, actually. We have hosted also keynote lectures online due to the, of course, well-known COVID-19 restrictions, but this is the first time that we go back to the webinar format, and we're very lucky to have with us Riccardo Luporini, Post-Doctoral Research Fellow at the Scuola Superiore Sant'Anna in Pisa, so a fellow Italian with us today, and another Riccardo with us, of course, the coordinator of the Gian Monnet module, Professor Riccardo Pavoni from the University of Siena. Professor Pavoni will make a short introduction, introducing our guest speaker, introducing also the topic of today's webinar, which is essentially one of the most interesting and growingly explored trends in international European environmental law, the use of human rights-based arguments in climate litigation. So, Riccardo, please, the floor is yours, and we look forward to the presentation by Riccardo. As usual, we will have space at the end for comments, which you can send comments and questions that you can send to us and to our speaker through the chat box on YouTube Live on your right. Riccardo Pavoni, the floor is yours.
So welcome everybody, also from myself. We are very happy to begin the new series of our webinars in the context of our Gian Monnet module on European and international environmental law, with such a topical discussion, which on human rights-based litigation on climate change. The speaker that is with us today, as Dario has already said, is Riccardo Luporini from the Sant'Anna School of Advanced Studies in Pisa. Is a research fellow there. He has recently obtained his PhD cum laude from that university, with a dissertation concerning the relationships between climate change, disasters, and human rights under international law. Riccardo is actually a very young and promising Italian scholar of international law. He's already had many experiences in our international law planet. For example, I just want to mention that he served as assistant to the special rapporteur on protection of persons in the event of disasters. That is Mr., as everybody knows, Mr. Valencia Ospina, at the 68th session of the International Law Commission. Riccardo also has a set of promising publications in the area of international law, dealing especially with issues of climate change and human rights, but also other topics. For example, I'd like to mention an article relating to offshore detention of asylum seekers, which is also very interesting in my view. Last thing that I want to say, that I don't want to steal any other time from his presentation, is that there is actually this is actually our relationship, my knowledge, my acquaintance with Riccardo Luporini started within Gian Monnet activities, because we met some years ago, precisely in 2018, at the Gian Monnet Summer School on Climate Change, Health and the Environment at the University of Salerno. That's where we met. We started to discuss the topic of human rights and the protection of the environment. And so that's why Gian Monnet is also responsible for our for the fact that we know each other. And so we were so happy to invite him to present within our first webinar this year. So Riccardo, the floor is yours.
Thank you very much for the invitation and for this too kind introduction, Professor Pavoni, and also of course Dario Piselli. So without further ado, I will try to share the screen. We are using, the audience is also on YouTube, but we are using a new platform for me. So we also had the test, and I hope that now you can see the screen, and I will launch the presentation.
It's working just fine. You can go ahead.
Great, thank you, Dario. Thank you very much. So, as it has already been said, the topic of today's talk will be human rights-based climate litigation. That is a growing phenomenon. Realities, potential, and drawbacks. This is the title of the presentation. Well, actually, I intended this presentation as, let's say, an advanced introduction to the topic. I don't have a precise line of argument. I don't want to address some specific issues, but I intend I think that could be a good compromise if in the audience we have more already advanced researchers on the topic, but also junior and senior researchers that might be very knowledgeable in law, international law, but maybe they are not very updated on these cases, and then also students, PhD, and so on. So this is the outline of the presentation, more or less, let's say three different sections with then conclusions. I will try first of all to define, to give a general overview of human rights-based climate litigation, and then frame this specific type of litigation within broader climate litigation as a whole. And then I will try to distinguish litigation before domestic courts. And in particular, here I will highlight, I will have a case example that is not an hypothetical case, but a real case. It's the first Italian climate case, the so-called Giudizio universale, or the last judgment in this very catchy name. That is, even here is intended, I will go in some details of the case, but is intended to provide a kind of, as I said, an example of a case. And so I will try to make reference also to more, general aspects that have been raised also before other courts, before within other jurisdictions. And then I will also try to highlight the possibility, of course, that this type of litigation occur before international human rights bodies, okay? And try then to provide my concluding reflections on the issue. So, first of all, climate change litigation in general is rising and rising. Here you can see the most, let's say, consolidated definition of climate change litigation. But I would say in general that we include in climate change litigation cases, and here we have a, let's say, quite broad definition of case, and this is also relevant for human rights, because we also include, let's say, quasi-judicial procedures in it, and cases that have to, of course, be related, that have to regard climate change and different aspects of climate change, different, for instance, policy related with climate change. First of all, climate change mitigation, so emissions reduction, but also, for instance, adaptation. So all these measures, activities that we have to carry out to adjust human society to the adverse effect of climate change, okay? And climate change can be at the very core of the case, or it can also be a bit more, at the periphery, let's say, but still the case to be classified as a climate case, climate change has to be an important aspect of the case, at least. And we have, for those that are interested in the topic, we have a wonderful, I would say, source of knowledge on these cases, that are these databases that you find here. They work in partnership. One is based at the Sabin Center for Climate Change Law at the Columbia University, and the other one at the Grantham Institute in London. And this is it was crucial tool for my research, and I think for many other researchers. And you can see there that there are almost 2,000 cases listed, included. As you can see from the graph on the left, this is still, in terms of the amount, the number of cases, very much an US phenomenon. Climate change litigation finds its origin in the US and is still very much a US phenomenon, but is spreading worldwide. It is becoming a really global phenomenon, and there will be, there are more and more cases also outside the US, important cases also outside the US. Within this broader spectrum, what is human rights-based climate litigation? When basically climate cases that rely in whole or in part on human rights argument, okay? So in whole or in part, because there might be some cases that use human rights as, they add human rights argument on other arguments grounded on, administrative law, tort law, and so on and so forth. And by human rights, we include both proper international human rights law and also constitutional, fundamental rights recognized in national constitutions. As you can see here, in terms of number of cases, this is a tiny fraction of the broader world of climate litigation, but they attract a lot of attention. They are growing a lot. And they are very widespread, as you can see on the graph on the right. It's mainly a European phenomenon, but it's very widespread different across the globe. And they are growing a lot, as I said. As for the outcome, half of these cases are still pending. This is because it's a quite new phenomenon. And then we have some successful and unsuccessful cases, even if, and this is an important point, we should define success in this type of litigation. It's not in success. It's broader and different than only legal, if you want, success within the courtroom. Okay, because these cases are much broader political, social significance. These data come from a work by Savaresi and Setzer, in particular, Joanna Setzer from the London from the Grantham Research Institute in London is very much on this data about climate litigation in general, human rights-based litigation in particular. So why they're attracting a lot of attention? I think because many of these human rights-based climate cases are strategic in nature. What do I mean? They are very high-profile cases that are prepared, let's say, strategically. They are prepared to have then, hopefully, a broader social impact, meaning an impact that goes well beyond the interest, of course, important interest of the individual litigants, okay? And indeed, we have a mix of legal and non-legal strategies. As I already said, political campaign, social mobilization built on the proper then legal action. Okay, and we have involvement of important environmental and social NGOs. And then, as I said, the proper strategy also is to choose the applicants, the appropriate forum, and so on and so forth. As you can see in the graph, also strategic cases are growing a lot. And as I said at the beginning, such type of climate case can be brought, of course, before domestic courts and then also national human rights institutions. I will not deal with national human rights institutions, but it's an important forum where you have national human rights institutions. We know that, unfortunately, Italy at the moment still doesn't have such institution, but hopefully something is changing. And so first we go a bit more into, let's say, into the details of litigation before domestic courts. Here I only provide, as you can see, an overview of cases brought in Europe. This is not to say at all that it's only a European phenomenon. It's just, for the sake of, let's say, for this presentation, but there are, it's climate change litigation in general, but also human rights-based climate litigation in particular is more and more a global phenomenon, and many cases are brought also in the so-called global south. Okay, so this is very important. But here, to stay in Europe, you have a list here that it's not exhaustive of quite, let's say, famous, well-known cases, starting, of course, from Urgenda in the Netherlands that has been decided in December 2019, a kind of leading on landmark case, and then many others in France, in Germany, and so on and so forth. Also cases still brought, still grounded on human rights arguments and brought against private actors, not non-state actors. So even more, if you want, groundbreaking, if you think at the Shell case in the Netherlands, but also at the pending case in France against Total. And we have, finally, also a case in Italy, okay, that is pending. So the first Italian climate case, Assud and others against Italy, or as it is known, Giudizio universale, so the last judgment. So Giudizio universale is actually the name of the campaign launched in 2019, social campaign, launched in particular by Assud Association, that is the leading association on the campaign and then on the case. And then in 2021, a proper legal action was brought against the Italian state before the Civil Court of Rome. It was brought by Assud Association, other associations, and a high number of individual applicants, also minors represented by their parents. What do they allege? What do they claim? The applicants allege that the Italian state climate action is inadequate, is insufficient. And this inadequate action, this inaction, infringes fundamental rights of the applicants. We already have actually a first hearing of the case in December, so last month, in the form of written notes. So we also have the reply by the Italian state that is not really published yet. I will make some reference to it, and then also the counter, if you want, counter reply by the applicants. Next hearing will be in June this year. So this is more or less an overview of the facts from the perspective of the applicants. Of course, they start by arguing that we are in a global climate emergency, that there is scientific consensus on the fact that we are in this emergency, and that there is scientific consensus that we have an important, significant gap in emissions reduction, meaning that we are not doing enough on a global level in reducing our emission if we want to meet those targets that have been then established, in particular with the Paris Agreement, of the well-known 2 degrees in the increase of average global temperature, even better 1.5 degrees. Italy in particular is a climate change hotspot for many reasons, geographical reasons and so on, and the Italian territory is very vulnerable to many risks connected with climate change, okay? Connected to climate change. The Italian state and the representative of the state are very aware of this emergency and many actions, also at the international level, if you want, just ratification of the agreements and also declaration and so on and so forth, prove that the state representative are very aware of the seriousness and urgency of this threat. Notwithstanding this awareness, the action by the state is insufficient. And in particular, this is, this specific case, the applicants do not look so much at what has been done until this moment, but mainly at the future, meaning at the targets and the projections of emissions reduction, in particular from here to 2030, because for climate science, 2030 is a very important moment, because we have really to, this decade in general is very important to significantly reduce emission if we want to stay within this target of 2 degrees and 1.5. So they argue that Italy is not doing enough, it's not doing its part, it's not doing its fair share to keep global warming within these targets. And this fair share, so what Italy should do, okay, according to its, if you want, responsibility, or better, to do its part, let's say, is based on science, and in particular on ad hoc reports that have been used in the case and prepared by Climate Analytics, that is an important independent scientific organization. What's the applicable law? Generally speaking, climate change law, of course, so starting from the UNFCCC, the Framework Convention, the Paris Agreement, EU law on climate change, then now there is also the new EU climate law, and this has not really been addressed in the complaint. This can be a bit of a kind of game changer maybe in the issue. And also the IPCC reports that, of course, are not binding. IPCC, it's the Intergovernmental Panel on Climate Change. It's a proper, actually international organization, but scientific organization. Reports, I was saying that they are not binding per se, but they are approved, signed and approved, well, first requested by state parties and then approved by them. And let's say that from this set of provisions, it emerged, and according to the applicants, a clear obligation for each state to reduce emissions and to reduce it to a certain given extent. And this extent is based, it emerged from the Paris Agreement and science, okay, and IPCC reports. On the other side, we have human rights law. First of all, the complaint makes reference of this very important development that we had mainly at the international level, and thanks in particular to some UN bodies, on the link, on this consolidation of the link. This is then the basis also of all human rights-based climate litigation, of this link between climate change and human rights. Okay, so not only the fact that climate change has an important impact on human rights, but also that states have positive obligation to protect human rights against the risk related to climate change. Okay, and then they make reference to the European Convention on Human Rights, in particular Article 2, right to life, 8, private life, and other important provisions, of course, Italian constitutions, and so on. And there is this important link, as you can see from the arrow, meaning that, from a violation of climate change law, then we also have a violation of human rights and some rights, in particular, of the applicants affected in the case. And then the case makes also reference to Italian jurisprudence, so more specific Italian aspect. I will not deal with that now. So they claim, the applicants claim that Italy is responsible for these violations under the Italian Civil Code, but they do not ask, and this is a very important point, for damage compensation. They ask for a declaration that Italy is responsible for this dangerous situation resulting from its inaction, in climate inaction, and then an injunctive order to the state to reduce emissions within 2030 to a specific high level that is 92%, that it does not come out of the blue, but it's what, according to science, or to the best available science, Italy should do to do its part, to do its part in the fight against climate change. So it is important to stress once again that this a kind of preventive legal action, meaning that really looks at the future. And this it brings some specific, if you want, also controversial aspects to the case. Counter arguments by the states, but more generally, let's say, points of contention. Okay, first, standing rights, of course. Well, the individuals and NGOs, because the applicants, we have both individuals and NGOs. Individuals have to prove that they have a specific differentiated interest to protect. NGOs, they have to prove that they are that they have a direct link with the interest that they want to protect, and also that they are representative, if you want to establish and representative in a certain sense, because of course no action popularis can be accepted. Okay, no action in the public interest can be admissible. Okay. So-called separation of power doctrines. What does it mean? Well, the state would argue that this is a quite intrusion, or would be an intrusion of the judiciary power into very political affairs, into legislative, affairs of the legislative and the executive branch that have that must have a discretion in deciding climate policy. Okay. And then about the responsibility, the two important points are, the first is causality, meaning that it is difficult to establish a specific causal link between greenhouse gases emissions and rights violation in general, okay? And then attribution, subjective attribution, it's very difficult to attribute such damage, harm, or in this case, human rights violation to the activity of a single state. Because the state can argue that, yes, we have a collective responsibility. I mean, the state can recognize the climate emergency and also some obligations to act, but this is a collective, let's say, responsibility, but not in we do not have an autonomous, independent responsibility of a single state to reduce emissions to a certain extent. Okay, so this can be a bit the points of contention and the counter argument. And then I just wanted to flag also other initiatives in Italy that still, I mean, they're included here because they are relevant for human rights, meaning that human rights arguments are also there. The first is a complaint to the national contact point of the OECD guidelines on multinational enterprises, and I think it will be launched. I mean, it has already been submitted, filed, but it will be officially launched today in a webinar in the afternoon following our webinar. And it regards in particular multinational companies that work in the field of intensive livestock farming in Italy, and of course the climate change effects of these activities. And the other one is a diffida, or notice to desist, I think in English, against any. This has been sent to any, to, let's say, in particular on again on the strategic plan of ENI from here to 2024, by arguing that ENI is not planning to reduce emissions enough. Okay, and we will see what would follow from this initiative in particular. And even here, even if we have a private actor involved, human rights are important arguments in the at least in this notice to desist. Okay. Then we change, let's say, a bit. We go to another aspects. Okay, so it's difficult after 20 minutes to come with to start another, let's say, chapter of the story, but I will try to do it because, as I said, climate change, human rights-based climate litigation, human rights-based climate cases can be brought before domestic courts, but they can also be brought before international human rights bodies, being them proper regional human rights courts, and also UN quasi-judicial human rights bodies. And these tables that you can see here, they come from a paper that I wrote with a colleague of mine, Arpita Codiveri from NYU University, in which we try to argue that, I mean, these bodies should have, and that will have, an increasing role in climate litigation. Here on the left, you can see cases that have been brought before the European Court of Human Rights so far, 4 cases. And on the right, you find cases that have been brought before UN Human Rights Treaty monitoring bodies. We should say that there are also cases that have been brought some years ago before the Inter-American Commission of Human Rights, in particular the Inuit, the very well-known Inuit case that has been Inuit petition that has been dismissed immediately, but it was really groundbreaking, and it has some, let's say, positive externalities on climate change litigation in general. And then, as far as for the UN, we should also say that there are possibility to bring complaints also to special procedures of the UN Human Rights Council. These are, even if you want, less judicial mechanism, but these are included in climate change litigation. But here I listed all, I mean, this table includes only cases brought before UN Human Rights Treaty monitoring bodies, okay? As you can see, well, actually what we tried to do in the paper was to provide a kind of typology of these cases, okay? And as you can see, the majority of these cases are still pending before the international human rights bodies. Big cases before the European Court of Human Rights have been communicated to the respondent states, and the court decided to give priority to these cases. So let's see how, I mean, the developments. And while on the UN side, we had two decisions that are decisions of rejection, actually, but let's say the academia itself, I mean, practitioners and also academics, they accepted this decision as significant openings to human rights-based claim litigation, to similar cases in the future, okay? This is the case for Teitiota and for also Sacchi, okay? The Teitiota case in particular has been brought before the UN Human Rights Committee, and it regards a specific aspect because it regards the non-refoulement obligation emerging from the right to life. So the duty not to send an individual, send back an individual that is asking for asylum in a country in which he can suffer real risk due to that are related, let's say, with climate change hazards. As in this case, in particular, Mr. Teitiota is a Kiribati national, and the risks were connected to sea level rise and flooding. And these aspects of international protection related to climate change is, I mean, an increasing, I mean, might be more and more relevant. And then, as for the rights that have been used as legal basis, you can find that, of course, the right to life or private and family life have been used in the European Convention of Human Rights Systems, and also in the UN, before the UN bodies. But also, interestingly, I think, the prohibition of discrimination, and in this case is intended of the prohibition of the discrimination of children or young adults, because they will suffer the most serious effects of climate change if we don't do something enough, if we don't do enough today. And then also another very important entry point for human rights-based climate litigation, it's rights to culture in particular, regarding, I mean, connected with indigenous peoples, indigenous groups, okay? The majority of the cases, almost all the cases, deal with mitigation, okay, so emissions reduction. Only one case deals also with adaptation, and I will come back to this in the concluding points. But what I wanted to stress in particular is one aspect, is that some cases are quite traditional, meaning that they properly exhausted, I mean, the applicants properly exhausted domestic remedies, and then properly exhausted domestic remedies, and then they brought the case before, they brought the complaint before an international human rights body. And they address a single defendant state, the state of so-called territorial jurisdiction, okay, in which they are based and in which the alleged human rights violation occur. Other cases are even more, if you want, innovative, meaning that the applicants went directly to directly before the international human rights body, and this is the case in particular for Duarte Agostinho and others against Portugal and others before the European Court of Human Rights, and the Sacchi complaint before the Committee of the Rights on the Rights of the Child. Not only this, they also, I mean, the applicants brought the case, addressed the case against multiple states, okay, not only a state of so-called territorial jurisdiction. So here, in the Duarte Agostinho case that is brought by, a group of 6 Portuguese children against Portugal, but against other 32 states party to the European Convention of Human Rights, including Italy. Okay, and the Sacchi complaint has been brought by young climate activists, including Greta Thunberg, against 5 states, so Argentina, Brazil, France, Germany, and Turkey. Okay, and these are 2 very interesting aspects, I think. On exhaustion or non-exhaustion of domestic remedies, what the applicants argue is that they do not have effective domestic national remedies at national level, in particular precisely because they address the cases to multiple states, and so they would find at the national level a problem of immunity, but also a problem of time. It would be unreasonably prolonged to go through all these, let's say, domestic systems. So it would be, or better, the only real effective remedy could come from an international human rights body. Okay, and on the other side, on the fact that they address the case to multiple respondents, of course, they base their claims on the fact that these respondents have an extraterritorial jurisdiction. Okay, meaning that the applicants fall within the jurisdiction of the respondent states, even if you don't have this territorial link. And this is a very, controversial, complex issue that now I will not go into the details of it after half an hour, because it would be a kind of suicide, but it is, of course, interesting and important. And if you want, I invite you to read both the decision of the Sacchi case, that was a decision of rejection because of the non-exhaustion of domestic remedies, but it is very open on this potential of establishing extraterritorial jurisdiction related with climate change, and then also the application of the Duarte Agostinho case before the European Court of Human Rights. These are available both within the database of institutions and the climate litigation databases that I mentioned. In particular, I think that the application by the Duarte Agostinho case is very well argued on this specific aspect of extraterritorial jurisdiction. That, of course, is, we have this possibility within the European Convention of Human Rights system, but this would be a quite innovative, a progressive interpretation of the extraterritorial jurisdiction, because it would not be based on effective control of a state on the territory or on the individual as such, but let's say, but I didn't want to go into details of it, but let's say control on an interest that is protected by the convention, and then on the other side is based also on this causal link between activities that take place in the territory of a state and that have effects on individuals that are based in the territory of another state. Okay, but I invite you to read this, for those that are interested, of course, to read this the decision and the complaint if you want to get to know a bit more about these issues. And finally, some concluding thoughts that I have. Well, sorry, just one moment. As the title of the presentation was Realities, Potential, and Drawbacks of Human Rights-Based Climate Litigation, I think that we should, let's say, provide some reflections, give some reflections on it as a conclusion. I think that this phenomenon, this specific type of litigation, has a lot of merits. In particular, it's very intriguing and fascinating for a young researcher, as a junior researcher as myself. And I think also that we had an unexpected development of this type of litigation. Now, I don't want to say that we have thousands of successful, positive outcome in courtrooms, so positive decisions. But as I said at the beginning, we should also be a bit broad in our views to what we actually mean by success here. Okay, so we have a development of this type of litigation, but as I said, I think until few years ago, even the more progressive academics would not have envisaged this type of development, and this is significant per se. Then, more concretely, I think that can be an instrument, a tool to push states and also private actors towards more ambitious climate action, once again, even outside the courtroom, for the political, social importance that this kind of cases have. And also, they are useful to prove, to consolidate, or to recognize finally the importance and relevance of the human right to a healthy environment as a whole, but with a safe and stable climate as a key element of this right. And this is, I think, very significant. In terms of limitations, of course, there are many, but one aspect can be, well, in which countries, in which jurisdiction can this the domestic human rights-based climate litigation succeed? Probably in those countries that on a global level are at the moment a bit more advanced in terms of climate action, or better, I could not imagine in particular human rights-based climate cases in some specific countries, and this is an aspect that we can consider. And then another important point, and this is why I stressed a lot the fact of these cases that were brought against several respondent states, because it is important but very difficult for this type of litigation to address the diagonal dimension of the link between climate change and human rights. What do I mean? That it is very important in terms of climate justice, that emissions are mainly released in some countries, and then effects of, adverse effects of climate change, so adverse effects of this emission are felt, and also, of course, human rights implications on the enjoyment of human rights are occurring in other countries, okay, or by individuals that for individuals that inhabit in other countries, okay. So this diagonal dimension is fundamental, but it's difficult to address it in litigation, okay, and this is a limitation, I think. Finally, some possible future developments, many, but what I want to highlight here, first, that we are speaking a lot about mitigation, but it is also very important to stress that we also have to adapt to climate change, and that might be, there are of course cases concerning adaptation, but even high profile, important strategic cases on adaptation, because mainly, if you want, in low emitters countries, so in the global south, for instance, it's key that adaptation is a priority, and it's also true that adaptation policies are not so advanced, and so this is another aspect that can be addressed, and this is what I'm doing research on, and I try to write something on this. Also, because actually, if you want, the link between human rights and climate change, it's easier if related to adaptation, if compare in comparison with mitigation. And then all the presentation actually was on strategic pro-climate litigation, but we should also be very aware that there will be, I think, more and more cases, so-called just transition cases. So cases that address not really the impact of climate change, but if you want, the implications that climate change response measures, so climate change mitigation, so climate change adaptation measures, can have on human rights. Okay, this is the other side of the coin, another part of the story, but it's very important, and I guess that this type of cases will have more and more attention in the near future. So with this, it's 40 minutes, so it's incredibly okay, and I thank you very much for your attention, and looking forward for comments and questions.
That's perfect. Thank you, Riccardo. It was a very, very interesting and exhaustive presentation. Now we have space left for questions. I encourage everyone to post your questions to your YouTube chat on the right, and I will make them appear here on the screen and read them to our speaker. Before this, to break the ice, I think maybe I can give the floor to Riccardo. I also have a couple of questions on my end, and we can sort of start discussions ahead of the questions from the audience. Riccardo.
Thank you very much, Riccardo, for your presentation. I think it was very exhaustive, very dense. There are so many aspects that it would be impossible to make all the questions that I have in my mind. So just say one comment. When you were, about the geographical aspect of this climate change litigation, because you showed all these graphs, you gave a lot of data here, which I think are very, very useful. And I invite everybody to read the paper that you co-wrote here, because I think it's really full of very, very interesting data and information about this. What is surprising to me is the absence of cases in Latin America, and especially before the Inter-American bodies, both the Inter-American Commission on Human Rights and in the Inter-American Court of Human Rights. And probably because the reason why I find this surprising, because that I think that the Inter-American bodies, of course, have been those more progressive when it comes to the relationship between the protection of human rights and the protection of the environment. And what I especially have in my mind is, of course, the very by now famous advisory opinion of the Inter-American Court of Human Rights on human rights and the environment, where of 2017, where of course, which is also very relevant in the area of climate change. So I'm not sure that I got very well your point about this limitation. You said that in which countries is more likely that this litigation succeeds, and you said that it's probably where the litigation brought before within countries that are more advanced in the climate action. I'm not quite sure about that, because I'm really waiting here on cases emerging in Latin America here, because I think that those courts could be very progressive also on the basis of the precedents of the Inter-American bodies. And especially because you said very, very well that one of the challenges here, one of the likely future developments is a focus also on adaptation issues. And when it comes to adaptation issues, of course, let's think about the indigenous peoples. And there is indeed one case brought by indigenous peoples, but before the UN Human Rights Committee. So I'm just thinking about all those so significant indigenous groups in Latin America. For example, those living in Amazonian, I know that you worked a lot about the issues relating to Amazonia. So I would like to hear something from you in this respect. Thank you.
Should I go? Okay. No, thank you very much for this point, because it's very important. Maybe I was not really clear. It's not that there are no cases. There are cases. I have been very Eurocentric in this presentation, but there are cases. I actually now I don't want to go back to the slide, but in the graph there were at the beginning there were also there was also indication of cases that have been brought in Latin America, domestic jurisdiction in Latin America. Let's think first of all in Brazil. Okay, we have a growing phenomenon of climate litigation in Brazil, in particular addressing the problem of deforestation, in particular addressing the policies or the omissions by President Bolsonaro, and climate change is related. It's an important aspect on these cases, and many of them are brought also on human rights arguments. So there are these cases. Okay, so it's very important to stress this at domestic level. As for the Inter-American human rights system, I meant, maybe I didn't mention, I don't know, the famous Inuit petition.
You did that.
Okay, that was dismissed. Then we had this Atabascan petition, a similar petition. I don't know if you know the case. A petition that was similar, let's say, to the first one, to the Inuit petition of the Inuit. Well, first, just to explain, both Inuit and Atabascan are two indigenous people that live in the Arctic. Okay, and the second petition, the Atabascan petition, was brought, I think, in 2013, but it's still pending. I think. I mean, we was filed with the Inter-American Commission. So, to the best of my knowledge, there was a bit kind of, silence. Okay, from there. But then we had, as you mentioned, the advisory opinion by the quite progressive advisory opinion by the Inter-American Court of Human Rights. So I think that we will also see developments from that side. So this is a very important point. So thank you for the questions, and also let me clarify, because maybe I was not clear. This is very important.
Perfect. I see that there are still no questions. I encourage the audience to post, because I see that there is an audience. So it will be interesting to convey some messages to Riccardo. Otherwise, you're also free to reach out by email, of course, after the presentation. But I can maybe continue here then with one of my own questions, and then we see where it leads us. Sort of one of the interesting things that you mentioned a little bit in this presentation, but you also it's sort of very well articulated in the papers that you wrote, that we posted also on the internet for our readers before this webinar, is the importance of the particular traditions, legal traditions and constitutional traditions of the states, of the legal systems in which these cases are brought. And this is, of course, quite interesting, because we've seen that in all the different cases brought over the past few years, how really the center of attention was really different from case to case, depending on really how a specific right is recognized in that specific legal system. And so for me, one interesting thing, looking sort of at the overarching international context, which is important both because, of course, maybe international developments might foreshadow then legal developments at the national level, but also because some cases, as you said, are brought directly on an international level, is sort of how recent developments on this international kind of plane, it might influence sort of the future of climate litigation. We know that of human rights-based climate litigation, as you know, as probably our viewers are aware, there was the Human Rights Council resolution passed last year on the right to a healthy environment, and a special rapporteur will be appointed on climate change and human rights. The Global Pact for the Environment has been discussed in recent years. So I'm interested in sort of your take on how these developments might kind of, support or at least give further impetus to human rights-based climate litigation.
Sure. Well, this is a very important point. I think that this development that we had at the international level about this consolidation, clarification first, then consolidation of the link between climate change and human rights. And this was thanks to the activities of, in particular, UN bodies. You mentioned special rapporteur. Well, you mentioned the new special rapporteur on human rights and climate change, but also the special rapporteur on human rights and the environment. Both John Knox and David Boyd, they were very much into this. And so all these activities were really the basis also for this type of kind of litigation. Of course, litigation, and then more specifically is expressly based on international human rights law, but also cases that mainly, as you said, they refer to constitutionally recognized fundamental rights, but still this set of international documents, resolutions, and so on, it's there, and it's, I think, the basis of all these developments. So it is very significant and important. Also, even if now at the moment we have an evolution or a development of this type of litigation, mainly before domestic courts, but still this international aspect is there in my view, and it's very important.
Thank you, Riccardo. Riccardo, do you have some additional points that you want to make? We are now at the 1 hour mark. I think we can stretch it maybe for 5 more minutes at the very latest. And in the meantime, I keep inviting questions from the audience.
Yes, in this regard, I want to add, Dario, that as I know that there are many Italian students listening and watching, so if you want to ask your question in Italian, then we will translate that for Riccardo Luporini, if you prefer to ask your question in Italian. No problem about that. I don't know, just in conclusion, I wanted to select perhaps what I consider most interesting here, most relevant. But perhaps another point of curiosity on my part is that when about the human rights that are usually invoked in this type of litigation, Riccardo Luporini recalled very well all the most relevant human rights here: right to life, right to health, right to privacy when it comes to the European human rights system. But then he said it was you, Riccardo, you seem the most interested in, let's say, human rights that are not usually considered here as much as those other rights. For example, the prohibition of discrimination on grounds of age and the right to culture. Why did you highlight those two rights?
Well, no, I didn't want to highlight those rights in particular. As you said, right to life, within the European Convention of Human Rights system, right to life and private life, these are the main legal basis. But I just stress the fact of the use of also the prohibition of discrimination, because it was, it's something, if you want, new and interesting, of a specific case that was the Duarte Agostinho case brought before the European Court of Human Rights. And then the rights to culture, yes, that one it's important, because it's relating with indigenous people. And as you said, I mean, I did some research in particular on indigenous rights to land and natural resources, and how they have been affected, in particular in the Amazon, for I mean in the due to many mega development projects that have been carried out in the Amazon and so on. And rights to culture, so intended as the rights to have their own specific, peculiar culture protected. It's an important entry point, I think, for litigation, for human rights litigation. In connection with, I mean, with in relation with environmental issues in general, and also on climate change. So that I would stress it because I think it's a very important entry point. It has been used in the Inter-American system and also before the Human Rights Committee.
Perfect. Thanks, Riccardo, for the answer to Riccardo's question. I want to highlight now a question that we had from the audience, from actually a colleague who was also involved in our previous Gemone module, Alessandro Palmieri. The Professor Palmieri is asking Riccardo Luporini, to what extent could the interaction between human rights law and tort law, which varies a lot from state to state, be fruitful in this context?
Thank you very much for the question. Well, a lot. This is mainly, I mean, I recall the Urgenda case here that was at the beginning, I think, I mean, the initial complaint, mainly based on tort law, on this duty of care that in the it's important in the legal system of the Netherlands, with human rights argument, let's say, as gap filler, or like as argument that were added to the main point on tort law. But then within the procedure itself, human rights argument became the main legal ground of the case, with this duty of care still there. So there is this important interaction, and of course, as it is highlighted in the question, it really depends a lot from state to state, as everything in climate litigation before domestic courts. It's very, as also been said by Dario before, it's really, I mean, depending on the, of course, on the national jurisdiction, the national legal system, and also how the case is built. If it is a strategic case, it will depend on how, I mean, on how the legal system is, the specific legal system in which the case is brought. Thank you very much for the question.
And I think we would also like to thank Professor Palmieri for the question. So we are now, it's now 4:05 in Central Europe. Riccardo, I'm not sure if you maybe had some concluding thoughts, both Riccardos really, if you have some concluding thoughts or words before we wrap up. I actually had a bunch of other questions that I will maybe ask you separately, Riccardo, because we're running out of time.
No, actually, we want to keep to our, tradition that our webinars just last 1 hour, because I think that is the most appropriate approach when it comes to online webinars and other activities. So we don't want to continue for longer. Let me just conclude by saying that this was a very incredibly interesting webinar. Of course, it did not cover exhaustively this area. That would require, let's say, an entire day discussing this topic. But I think it was that Riccardo Luporini gave us information and arguments and points which are also can also constitute the basis for research and for detailed approach to this area for the many people who are now becoming interested in this topic. And of course, when it comes to these people, I also think about very, very young people. Next year, for example, my children should be very, very interested in this topic, because I'm always repeating that we are discussing about, most importantly, about the rights and interests of future generations here. So I think that this should be something that should be also taught more intensively at a very basic level of education in all our schools, also primary and secondary schools, because I think that these cases teach us a lot about the future of the law and the future of policy and the growing importance of the fight against climate change. So thank you so much, Riccardo, for being with us, and I give you the floor for your final remarks, if any.
No, I think that your final remarks were great, and I would only add that I'm more than happy, and I'm very available if any of your students or young junior researchers, PhD, have some questions and so on. I'm available by email or whatever, in whatever form. So thank you very much for the invitation. Thank you very much. It was a pleasure and an honor to take part in the activities of your Gemone module. Thank you.
Thank you, Riccardo. You sort of anticipated me in a way, because I was going to speak on your behalf, signaling your availability to receive questions and comments. But you did it yourself. So it's. I just want to conclude by saying that it's been really a pleasure also on my side to have you, and I look forward to continuing engagement between not only the two of us, but the three of us and the entire community who participated today. We will keep the audience informed in due course about our next webinars and events. And we thank you again for participating, and we hope to see you all soon.
Thank you. Thank you very much.